Welcome to Government Contracting Weekly, sponsored by AOC Key Solutions Incorporated. Government Contracting Weekly is the only television program devoted exclusively to the competitive and dynamic world of government contracting. A world where coming in second place is not an option, but where principle-centered winning is the only approach.
Good morning and welcome to Government Contracting Weekly. I'm Jim McCarthy, the owner of Key Solutions and the host of this show. Whatever the process was that got us all to where we are today, bid protests have gone from once being relatively rare to a fairly commonplace occurrence within the federal contracting community. Today, I'm joined by Amy O'Sullivan, a partner at the law firm of Crowell Moring, and she's going to help us to understand the various types of protests, their leading causes, the frequency, and the number of other issues that have become a critical component of winning and retaining government contracts. There is a lot to cover, so let's get right at it. Amy O'Sullivan, partner, Crowell Moring, expert in protests filed with federal agencies, GAO, and Court of Federal Claims, expert in limitations on subcontracting, 8A issues, mentor-protege issues, and avoiding improper affiliations. Clerk, Eastern District of Virginia and Norfolk, and a graduate of William & Mary Law School. Welcome to Government Contracting Weekly again.
Thank you.
Good to see you. Okay, so here today about protests, all right? So we're hearing a lot about protests, and you often hear about protests against an award or something like that, but there are various types of protests, are they? What are some of the other protests that are out there?
Well, some of them are differentiated based on timing. The big distinction when we talk about bid protests is whether something is pre-award versus post-award. Pre-award challenges largely fall into a bucket of challenges to the terms of a solicitation. Post-award challenges are about the agency's evaluation and award decision. Beyond that, the term protests can refer to size and status protests, issues, for example, that could be before the U.S. Small Business Administration.
Right. Well, there's some timing issues that take place. In other words, you have to file timely in order to be eligible. Is that correct?
Absolutely. One of the biggest risk issues that companies face is knowing what the time deadlines are, because they are very tight. If you are challenging the terms of a solicitation, you have to be very much aware of what the issues are before your proposal goes in. If you wait until after an award decision is made, saying you just want to gamble it and see, well, I have a question about what the RFP says, but I'm going to wait. Maybe I'll win it regardless. And then companies try to raise a challenge after that award decision. It's too late. Okay.
There was a time, at least I thought, when protesting was sort of stigmatized. Companies were reluctant to do it. Now I don't detect the same fervor or same attitude against protesting, I guess I would say. Have you seen the same thing? Is it increasing?
The stigma has been removed to a large degree nowadays. The concern historically had been essentially you're suing your customer. Yeah. There's an awkwardness, a concern about a perception of resentment, a concern that there could be an impact on what an agency thinks of you during the evaluation, even if you prevail in that protest. Right. Nowadays, it is rarely the case that you'll find a company say, I don't protest. It's almost because the trend of protests has increased. Small companies, large companies recognize that it's almost an inherent part of the procurement process. It's an expectation that after an award decision or during the solicitation process, that companies will exercise this right and utilize it to its fullest degree.
Okay. So talking on the subject of protests against awards, are there some patterns that you're seeing? In other words, what are some typical grounds that a company may assert in terms of its protest?
In a post-award situation, it's interesting because what a company will assert initially is often not what the real issues end up being in a bid protest. Going in, companies often have very little information. It's what has been largely provided to them through the debriefing process, which will be very high-level information about evaluated strengths and weaknesses about your company as well as the awardee.
Of questionable utility, I might add, as well, in terms of usefulness for a company getting that kind of feedback.
Debriefings are an absolute, and it's a recommendation that I tell companies to take that debriefing regardless of whether you are the awardee or not. It is a way to learn from agencies about what they liked and didn't like about your proposal, because the procurement process is an ongoing cycle. And so you can learn from the issues each round to help make your proposal more effective next round. So it's not just a process to gain ammunition for a bid protest. It's also to enhance your proposal in future rounds of the procurement.
Is there any chance that government circles the wagons, if you will, when a protest is lodged against an award, that they're going to do their best to make sure that the contracting officer and his or her team prevail?
Well, the agency can only do so much after the fact, because an award decision can only be truly defended by what is in the record contemporaneously.
Right.
When we are litigating bid protests, agency counsel who are not involved in the underlying procurement will try to defend that award decision, but they can't create a record that didn't exist at the time. They can fill in the gaps to a certain degree, but those evaluations, those decisions that were made and documented at the time that those decisions were made, are going to have to be the basis for supporting that determination.
Okay. I understand there's different types of venues for where protests can be filed. Talk to us about that.
Well, generally in the bid protest context, there are three options for filing and pursuing a bid protest. The first is at the agency level. This is one we don't hear about very often. There's not sort of a published database of decisions. There's not really a lot of statistics out there on agency level protests, because essentially you're going back to the very same customer who made the decision and say, I think you got it wrong.
Right.
And so it's a very informal process, and there is not a lot of transparency in what happens during that process. You just get the result. The most commonly used process is at the GAO. That is before true bid protest experts. This is where we tend to have most of our action. It's a very formalized process. It's very fast-paced. From start to finish, protests are completed in 100 days. Other option, which can be the option where you go to initially, or it actually can be a secondary option after a GAO protest, is the U.S. Court of Federal Claims. More formalized litigation. It is a true court forum. And there are different processes and procedures that apply at the Court of Federal Claims versus GAO.
Okay, are there any prospects that would say that the protest is nothing but sour grapes, and that bidders, or offerors, if you will, apparent awardees, are merely filing to go through the motions? Is that
I mean, there's an expense with the process,
Yeah.
and I mean, it does delay the actual implementation and commencement of a new contract. Where you hear that perception about bid protests is when you have an incumbent. So they're going to utilize the process to hold on to their contract.
Amy, we're going to cut away for a brief commercial, and we'll be right back.
I'm Kevin Madden, the Vice President and General Manager of Honeywell's Federal Systems Group, with another government success story. In 2002, Honeywell started working with the GSA to reduce costs and provide a reliable source of energy at White Oak, the FDA's new headquarters. Today, White Oak can separate from the local electricity grid and sustain operations when there are outages, which they've done more than 70 times over the last 3 years. To make sure the FDA has the power to protect this critical research, even during Hurricane Sandy. Honeywell has helped more than 150 agencies improve core infrastructure, facilities, deploy renewable resources, and trim emissions, often accomplished through guaranteed savings. Your mission is to make the country a better, safer place. Our mission is to help you meet your energy goals and mandates. For more information, visit buildingsolutions.honeywell.com.
So, did we win that government contract?
We did.
And?
And now we've got to deal with the regulatory hurdles.
Well, good luck with that.
When the government's your client, you need to play by their rules.
Ah, and the rules change more than you think.
Exactly. We need someone who's done this before. Plus, it's complicated, so we're going with BDO.
BDO.
People who know government contracting know BDO. AFCEA has been bringing government and industry together since 1946. By joining AFCEA, you will reach the decision makers and become part of the discussion. You'll increase market visibility, gain market insight, receive discounts on AFCEA member services and events, and manage and engage corporate associates. AFCEA is the association of choice. Join today at www.afcea.org.
Welcome back. I'm here with Amy O'Sullivan from Crowell Moring. Just to follow up on what we were talking about, let's go back and look at some of the leading causes or allegations of protest. What causes a company to want to lodge a protest?
Well, a lot of it can turn, again, if we're talking about the post-award protests, will be sort of a feeling that an evaluation wasn't handled properly or fairly. And this could be with regard to a company's perception of its own evaluation or the feeling that the awardee's evaluation was inflated, improper, or inconsistent with what they know about the company or, for example, their past performance. It gets more complicated in more complex procurements where there are rounds of discussions, so it's not just simply the process of submission of proposals. Initially without that back and forth opportunity. And so there can be more issues that arise in those more complex procurements as there's the ability to make revisions or changes throughout the procurement process.
What are the typical remedies that a company seeks when it does make a protest?
Well, the ideal would be to simply get the contract. That is rarely the case coming out immediately from a protest, that you would get what is called a directed award, where GAO will essentially look at the record and say, actually, you should give the award, contract award to the protester. The most common types of relief where a protest goes all the way through to a decision is going back and having a reevaluation done. There can be a range of forms of relief, from the opportunity to submit revised proposals to, again, simply the reevaluation, but then ultimately a new award decision being made following the correction of the mistakes that have been identified.
So, in terms of thinking about an award and a decision and a protest, let's say that a protest is lodged and it in fact prevails, and the GAO directs the agency to recompete or resolicit. Many companies would say, well, you know, I've won the battle, but I've lost the war, because if they didn't want me the first time, just because they've been told to rescore, they'll find another way to make the outcome as they wish. What reaction do you have to that?
That's not always the case. It is fairly common to see an agency go back and simply fix the mistakes so that they come to the same result as they did previously, but cleanly and correctly and in a manner that's well documented. However, it has been the case on multiple occasions that I've been involved in where when an agency goes back and does the evaluation properly, considers factors or issues that it hadn't reviewed before, hadn't appropriately considered, that there can be a role reversal.
There can be a role reversal, okay. So in the case of incumbents, it's been observed by some people, and there have been some articles written on it, that incumbents now have come upon a new strategy. Should they lose their recompete, they have a knee-jerk, which is to file a protest because they get 5 or 6 more months or even longer of activity and revenues. Have you seen that at work in the marketplace here?
I have seen that as a factor. It is dangerous for that to be an exclusive factor because remember, again, rarely would it be a situation where this would be the only procurement or contract or opportunity that this company would be before this particular agency. And to have a situation where you're simply filing to file to stall, to buy extended contract performance, that's often reflected in the nature of the protest. A protest that looks frivolous on its face, it's recognizable, and it does send a bad message.
So the strategy is transparent and it's not advised, is what I hear you saying.
It is typically what I have with companies, whether they're the incumbent or not. Immediately upon knowing that there is the potential for a protest, we have an extended conference call. And it is truly a business decision ultimately that arises out of it. There are multiple factors, including the incumbent status and what it means from a revenue standpoint for a company. But you know, the costs of filing, the likelihood of success, whether we have good issues or not, all of this comes into play as part of that discussion.
The GAO, is it more likely to overturn a protest based on the merits of substance and content or on procedural mechanics?
The real issues are going to be ones where it's a black and white. It is something where the agency has a lot of discretion in setting the ground rules of a procurement, but it has to follow them. It is much more difficult to challenge an agency determination that is truly something that is subjective.
A judgment.
So, for example, a best value determination. Agency has a lot of flexibility in weighing cost versus technical issues and determining ultimately what is going to prevail, carries the greatest weight at the end of the day for the agency's purposes, versus saying a black and white type of issue that you had to consider a specific sub-factor that the agency failed to do.
Right. Okay, well, we're going to step away again for a break here. When we come back, I'd like to talk to you about what can companies do to essentially protest-proof their proposals.
Working in contract management is a complex job. Creating, executing, managing contracts. It's an ever-changing world, and our members share the same challenges. At the National Contract Management Association, we know this business, gathering the best minds in our field, furthering your career by providing knowledge and training. Together, we've figured it out.
Since 1941, the USO has been lifting the spirits of America's troops and their families. Members of our military continue to make sacrifices and defend our nation. That's why the USO of Metropolitan Washington, Baltimore is committed to serving them throughout their years of service. USO Metro is the way for you to say thanks to our local military members, their families, and our wounded warriors and caregivers. Please visit us at usometro.org.
Good morning, my name is Alan Horlick and I'm the executive producer of Government Contracting Weekly, which is currently in its second year on television. Now, as we move into a new year, I want to share with you some exciting news, and that is our decision to begin producing and airing commercial messages. This unique program attracts a pure concentration of both industry and government decision makers. As an advertiser, you can't afford to waste your money. So whether you are a contractor or a service provider, Government Contracting Weekly offers you the perfect environment and the perfect audience so you can make your own best pitch on why you should be hired. If you'd like to learn more about advertising in Government Contracting Weekly, you can contact us at governmentcontractingweekly.com and click on Advertise.
I'm here with Amy O'Sullivan. Amy, question for you in this context. Is it considered a black mark or a stain on a contracting officer's record if a protest is upheld at the level of GAO or something? Is it considered? Well,
it's not something that's exclusively a contracting officer's responsibility or where you would look to place the blame. The results of a procurement are a team effort. It's the contractor's proposal. It is also multiple teams of evaluators who often have responsibilities for different aspects of the evaluation process.
So it's not like the heads are going to necessarily roll because the government lost a protest or something?
It's not to say that there are not egregious errors or mistakes that can certainly look bad when they are written in a publicized decision.
Okay, let's follow up on mistakes. What can a bidder do to, quote, protest-proof its proposal?
I wish I could give you a solution to make a proposal Loctite from bid protest. But as I said, the end result and the protest process follows on several components. It's the proposal as well as the evaluation. You can have the best proposal in the world, but if the agency doesn't do an effective and thorough job in the evaluation, you're not going to have a protest-proof proposal.
Right.
There are things that offers can do to help avoid having winnable protest issues.
Okay, why don't you just kind of tick off a few of those for us?
A few of those, one obvious one that comes up at the forefront of the proposal process is who you have on your team. Avoiding conflicts of interest, making sure that you are vetting your subcontractors, teaming partners to ensure that that isn't an issue that you create by who is participating in your proposal itself. Other issues are writing a readable, thorough, complete, and consistent proposal. And so we aren't leaving it open to the agency to guess what it is that you meant, to have it where you weren't following the requirements itself. Incumbents often make a mistake of assuming that an agency knows something about its experience or its ability to handle the requirements. If it's not there in black and white on the face of the proposal, you can't make that assumption.
That's right. Okay, so let me ask you, what is the ostensible subcontract rule? Are you familiar with that in terms of affiliations and improper affiliations? Can you talk to our audience about that, please?
The ostensible subcontractor rule actually comes into play not in the bid protest context. This actually comes into play in what can be a difficult scenario where you have to run 2 protests at once. And this is a small business issue. So in procurements that are issued as small business set-asides, issues that go solely to the status of a company, whether it is 8A status or size, have to be litigated before the SBA, versus the true procurement issues and evaluation issues go to GAO. Now, an ostensible subcontractor is where you have the small business is proposed as prime, but it has a large business sub who is essentially acting as prime.
And the fear is that the prime, the big business, is pulling all the strings.
Absolutely. Right? Yeah. It's a complicated analysis. It's a multi-factor test that SBA considers the totality of the circumstances.
Well, if the small business still gets a share of the work, why does the government necessarily care that it's being backed by and controlled by a prime big contractor?
It's not simply that it has a large business as its subcontractor. It is the role that that large business plays. Because if a procurement is set aside for small businesses, we want them to be the true beneficiaries. We want them to act and learn to be the prime contractors and not have the large business inappropriately trying to take more than its fair share.
Okay. Well, we have about 30 seconds remaining, and one final question for you. It's really an opportunity. If you had to leave one message with our television audience that is important to them to know as they do business with the federal government, what would that be?
I mean, an important issue really is going to be being aware of the timeliness requirements and thinking about issues in advance, particularly when an RFP comes out. You need to be vetting that procurement with the protest process in mind up front. Are there issues, ambiguities up front that you need to address, and do so before proposal, and use communications effectively with the government to get issues fixed before you actually have to pursue litigation. And then at the end of it, following the award decision, to consider protest lawyers not exclusively as your litigators or lawyers, but also as an integral part of that business decision. We actually are an essential component of a company being able to keep a contract. Right. And so we actually can advise in all of those considerations that a company should keep in mind as part of that process.
Well, thank you. First of all, I'd like to thank you very much for being on the show today, Amy, and we hope we get you back again sometime. And right now we're going to break for a commercial.
In this hyper-competitive marketplace, as a federal government contractor, now more than ever, you need to identify, track, forecast, and analyze opportunities that will help you grow your company by better positioning yourself to win contracts. I'm Jamie Brett, the founder of Easy GovOps, and that's our mission. Utilizing the most intuitive market intelligence platform, Easy GovOps, enables contractors of all sizes to manage their pipeline, collaborate, and team like never before. Experience for yourself the power available to you and your team with a 5-day free trial period with no commitment necessary to begin. Simply visit easygovops.com to start your free trial today. Join the hundreds of other federal government contractors who are enjoying the ultimate competitive advantage of our unequaled market intelligence. Just spend one free week at easygovops.com and see for yourself.
Questions. Do you lack win strategy, themes, and discriminators? Are you being outmaneuvered by your competition? Did you get a late start on your proposal? If you answered yes to one or more of these nightmare scenarios, we can help. Hi, I'm Jim McCarthy, owner of Key Solutions. We help government contractors win government contracts. And for over 30 years, KSI has helped clients win or retain over $130 billion in government contracts by providing the keys to winning. We assist companies both large and small to enter the U.S. government contracts market or to increase their market shares. We have worked with 87 of the top 100 government contractors and literally hundreds of small businesses. So if you're chasing a must-win contract opportunity, go to our website, aockeysolutions.com, and click on Win. It's a tough market out there. Don't go it alone.
At KSI, we're often asked about the importance of RFP compliance and whether the government would actually be so strict as to turn its back on a superior approach and low cost, merely because the proposal had some minor non-compliances. Well, here's the KSI take on that issue. According to most RFP language, the government has the right to overlook minor instances of non-compliance, and they often do. If your proposal really does provide a better approach in pricing, it's likely the government will overlook any non-compliances. The government isn't vindictive when compliance is concerned. It won't use this to interfere with getting what they really want, but, and this is the important part, it will use all elements of the procurement process to weed out proposals that don't hit the mark. Compliance is one of the tools in their toolbox. But that's no excuse to let down your guard. Remember, non-compliance does not make the offerer look good. Generally, it means the offerer can't read and respond to instructions, is sloppy, or is thumbing its nose at the government. Those are not attractive attributes for an organization that wants the government to buy its products or services. At Key Solutions, we're all about helping you win or retain your next contract. If you have a question, please visit us at governmentcontractingweekly.com and click on Inquiries at the top of the page.
It's clear that protests have become a regular part of the federal government contracting landscape. And for better or worse, it's also clear that you need to understand the implications of this issue if you want to win and retain contracts. I want to thank Amy O'Sullivan, a partner at the law firm of Crowell Moring, for joining me today. But most importantly, I want to thank you, our viewers, for once again making Government Contracting Weekly a regular part of your learning regimen. On behalf of all my colleagues at Key Solutions, I'm Jim McCarthy, and I'll see you next week.
You've been watching Government Contracting Weekly, sponsored each week by AOC Key Solutions Incorporated. Government Contracting Weekly is the only television program devoted exclusively to the competitive and dynamic world of government contracting. For additional information, comments, questions, or suggestions, please write us at governmentcontractingweekly.com.